So misrepresentation by the seller as to the condition of the property usually has to be proven in the sense that a misrepresentation is an act by the seller. So it can be an intentional misrepresentation or a negligent misrepresentation. Intentional is when the seller knew about it and chose to represent it differently or omitted to represent anything at all, whereas negligently is when the seller should have foreseen the consequences of failing to conduct himself or herself properly, and yet continued with, basically forgetting to speak about it or forgetting to disclose it. Now, insofar as the onus is concerned, yes, the onus unfortunately does sit on the purchaser to prove that it was indeed a misrepresentation. And if one, for example, is looking to basically not get away from the voetstoots clause, if a purchaser wants to prove that the seller knew about it or should have known about it and doesn't want the seller to rely on the voetstoots clause as an example, then the purchaser would have to prove that the seller somehow knew about this. And we have case law that guides us when it comes to things like this, but you typically tend to find that it is a very technical argument. And for example, you need to call in experts that would look at if it's the condition of the property, when the initial repair took place, if somebody painted over it recently, that they should have known, for example, arguing that there wasn't a leak when it can clearly be seen in the ceiling that there was a leak, but the ceiling had been recently painted. All these type of situations go to infer that the seller actually did know and yet chose to hide a defect, if we're speaking about defects. So yes, misrepresentation comes in many shapes and forms. Some can be inferred from the facts, but the onus in those situations would fall on the purchaser.